Grear, and I am with Pfalzgraf, Beinhauer, Grear, Harris, Schuller. We are an elder law firm, so I've been doing this type of work for about 28 years. I date myself when I say that, and I always feel really old saying that, but it is what it is. So my hope and goal today is to impart some information on all of you, address questions that you may have with regard to some basic estate planning. As Christy mentioned, if you do have a question, please feel free to put that into the chat and Christy will monitor that. And then as I sort of finish a section, I'll ask if there's any questions, and then we can make sure that any questions you have get addressed as we move through the presentation. So as you can see, I do have a PowerPoint that's up here as well, and we'll be using that today to go through the material. And if anybody would like a copy of the PowerPoint itself, you can feel free to email me directly and I can shoot you a copy of the presentation itself. So my email address is greer@pbelderlaw.com. You'll see that at the bottom line there on the presentation slide that's up right now. I'm happy to provide the packet to anybody that might want that at a later date. So to get started, when we talk about estate planning, I generally will start with basics and then we'll layer on a few complexities as we go. I do tend to speak with my hands, and I apologize. I'm Italian. There's no stopping it, so I apologize. Hopefully it will not be too distracting for anyone. But there are 4 basic documents that every individual should have. So regardless of age or financial circumstance, we want to make sure that everybody has a last will and testament, a disposition of final remains, a healthcare directive, and a power of attorney. And we're going to be drilling down into those documents this morning. So the first document is a last will and testament. And a last will and testament, you're probably familiar with, is basically a list of instructions to be followed after you pass away about what to do with your assets, your stuff, and instructions about how those things should be distributed, any specific care that you might want to put in place about how people receive things. What I mean by that is if you have maybe an heir of yours that may be younger or under a special need, we want to make sure that we're appropriately protecting those individuals. So within your last will and testament, you can create perhaps trust provisions for somebody. So in your mind, please remember and recall that if you happen to have somebody in your family or in your close friend group who you would be providing for, who has a special need, we need to make sure that we're specifically protecting them. So for minors, anybody who's under the age of 18, under New York state law, they are entitled to inherit once they attain the age of 18, unless you specify otherwise. And as we know, 18-year-olds are not always the most mature to handle the money. So we would generally recommend that if you have minors involved in your plan, that we provide a trust for them in your will that maybe protects the assets until maybe they're 25 or a little bit older. And the funds can be used for their health, education, general welfare, but that those assets are then protected for them. Likewise, if you have somebody in your family unit who has a developmental disability or is a person with a disability, those individuals might be receiving SSI and Medicaid benefits. And if they are, we do not want, with the best of intentions, to give them an inheritance that suddenly knocks them off of benefits. So for a person who has SSI, they cannot have more than $2,000 of assets at any one time in their name. And if they suddenly inherit an influx of money, we just actually harmed them, and we don't want to do that. So we can provide for somebody who has a special need by way of something called a supplemental needs trust. So keep in mind, if you have somebody in the family unit who is receiving government assistance, such as SSI or Medicaid, we can still provide for them. The assets in that trust are not owned by them, therefore they're not considered as assets of that individual, but the assets can be used for their life, and making sure that there's extra quality of life items there for them and have the funds available for them. I do want to take a couple minutes and just talk about digital assets because they are becoming more prevalent. So tips for planning for the digital age. We want to make sure that if you have digital assets, and this can be online accounts, it could be cryptocurrency, it could be just social media accounts, Facebook, Instagram, again, any online account, you want to make sure that your fiduciary, your executor, is going to be able to access these assets at some point in the future. And it's important to make sure that the person that's controlling your assets after you pass knows to be able to protect your identity, preserve your identity, and be able to collect your assets as well. So we do not want assets to be lost simply because somebody didn't A, know about them, or B, know how to actually collect those assets either. So it's important to make sure when you're picking who the executor of your estate's going to be, that we think about a person who is good with detail, good with organization, and good with follow through as well. All right. So when we are talking about planning for the digital age, we want to make sure digital assets get inventoried, somebody's comfortable with dealing with them, and make sure that your estate planning documents, like your will, expressly authorize your executor to be able to collect those digital assets. And I also recommend that perhaps you have some sort of data storage for those assets as well, so that somebody knows how to get to them. It could just be just keeping a ledger and making sure somebody has your passwords and your information. But if those assets are not accessible after you pass away, they are potentially lost and then exposed to others collecting them. So we want to make sure that those assets are protected, and we take steps in advance in your documents to assure that those are protected. Anybody have any questions on a last will and testament?
There's none yet.
Okay, I'm going to move on to the second document, which is appointment of agent to control disposition of remains, which is a long way of saying somebody to take care of your physical body after you pass away. So who's going to be in control of making decisions to work with the funeral director? So, if you, for example, want to be cremated and you have specific instructions about what is to be done, that should be in a written document. If you would like there to be a religious service or the lack thereof, you want to put that into a written document. You may appoint an agent or multiple agents to make these decisions and to work with your funeral directors. These are particularly important documents if we suspect that there might be a power struggle or a dispute later on. So, for example, if we have a second marriage situation and perhaps there are children from the first marriage, we have a new spouse and maybe they're at odds about what is to be done, we want to avoid those disputes after we've passed away. We, in writing, can put together a document to indicate who's going to make the decisions. That person has the power. And then we can also indicate whatever our specific instructions might be. And the funeral directors really like to see these documents because it allows them to know, who am I talking to and what directions do I have? And there's a written document, and the statute tells them that they follow that person's directions. So the funeral directors really do like to see this document in place. I often have people tell me that they want to donate their body to UB for science. Many clients will say that to me. If you do want to do something like that, it is important to know that that anatomical gift needs to be completed before, or the paperwork for that needs to be completed while you're living before you die. So all of that paperwork is available online. You can actually just Google anatomical gift, University of Buffalo. All the forms are there, but you do need to have that all completed in advance with UB. And then after the donation is taken with UB, they will cremate you, and they give you options as to what's to be done with cremated remains following your passing. Any questions on disposition to control final remains? Or any other question?
You have a couple questions.
Okay, go ahead.
The first is, if I'm on Medicare and I get my husband's stuff, do I need to pay taxes?
So if you're on Medicare and you're getting your husband's an inheritance from your spouse, so any inheritance that you receive from anyone, whether it be your spouse or any other person, is not going to be subject to income tax, with the exception of something that was tax deferred. So, example, if you are receiving something like a retirement account, like an IRA can generally be rolled over by one spouse to another spouse, and you can just put it into your own IRA. But if I am a child and I'm receiving an IRA from my parent, as an example, I don't pay income tax on the initial receipt of the account transfer, but as I start taking money out of that account, somebody has to pay the tax because my parent did not pay the tax. So there's tax on that, income tax. But there's when you receive an inheritance, it's not earned income. So the general rule is there is no tax on something you receive as inheritance unless it was a tax deferred item. Other questions?
Can I have more than one executor?
Yes. So for executor, you may have more than one. Keep in mind, if you name multiple executors, that they have to work together. So that means the more people that you put into the mix, it gets a little bit more cumbersome. So they have to consult with each other. They may have to go to the bank together. They may have to do all of these steps together. So you absolutely can have more than one, but the more people you add, it just becomes a little bit more cumbersome.
Okay, is this I'm not sure which form this is referring to. Is this a specific form to be filled out, or is this similar to a will that is created from scratch?
So I am
Also,
assuming that this is probably about the disposition of final remains, and it is a specific form that is actually filled out. So the New York State Public Health Law, referred to Public Health Law 4201, actually sets forth what the form actually looks like. And it's similar to like a healthcare proxy form in New York, where we actually have a state statute that tells us what the form looks like. So you really do want to use that format. But it is available. You can kind of look at the 4201, and the terms of what that document should contain are in there. It does need to be signed in front of two witnesses. So if you're going to prepare a document, you're going to sign it in front of two disinterested individuals. Similar to a will, when you make a will, that is a legal document that has to be completely written. All the terms contained therein, and you have to sign it and declare that it is a will in front of two disinterested witnesses. So meaning that one of your beneficiaries cannot serve as a witness, and similarly, one of the agents that you appoint to control your final remains cannot be a witness. Any other questions?
Where would you find that form?
So, I mean, obviously an attorney can assist you. I think a lot of funeral directors might have them, or you can Google New York Public Health Law 4201.
And then if someone passes away, do they have to write down what they want done with their body, or can their child make that decision for them?
So the family can make the decision, but having this legal document actually gives you more validity to that child. So for example, if you have 3 children and 2 kids want to do one thing, you know, 2 children want to do burial and 1 child wants to do cremation, and there's a fight about what we're doing, having this legal document can actually avoid those disputes. But legally, you don't have to have this document. It's just that, you know, and the executor, whoever you name as the executor, can make your final arrangements. But if you expect there to be any disputes, or if you have very specific, unique wishes that you want followed, you want to put that into this document. Any other questions?
Okay, that's it for now.
Okay. So posting where you can get anatomical remains. So that is, I can't do that now, but I can certainly try to email you. If you want to email me, I can give you the information, but it's University at Buffalo's anatomical gift. If you Google that, you'll be able to find all of the forms right there at the UB website. Okay, planning for your funeral. I highly recommend that you do take the steps in advance to at least put down into writing or have the conversation with your family about what you do or do not want for funeral arrangements. When you do pass away, your family is dealing with the fact that they are grieving for you. Sometimes people are just tired, they're in shock, there's all of these emotions happening, and now they're being asked a barrage of questions by the funeral director about what do we want, what is the obituary going to say, are we going to have a funeral service, how many are we going to have a viewing, how many days, all of these questions that need to be asked, and your family may not know what you would want. So have the conversation in advance. Try to put something into writing. And if you can pre-arrange your funeral with a funeral director, all the better. You can pre-arrange with funeral homes. You can even prepay for your funeral in advance. And I highly recommend pre-planning your funeral if you're comfortable doing that. It will help your family after you've departed this earth. Okay, the next of the 3 basic documents I mentioned is a healthcare directive. And in New York, we actually have sort of 3 different healthcare directives available to us. We have a healthcare proxy, which is just that standard state form that you get if you go into the hospital for surgery. They give you that 1-page standard form. That's just a state standard healthcare proxy. And the healthcare proxy says, I appoint this individual and they know what to do. So it's very basic. It appoints a person. You may have a primary person and a backup. I highly recommend that you have at least a primary and one backup, so that if your first choice is deceased or unable to serve, that you have a backup listed. New York state law says you can only have one healthcare proxy at a time. You may appoint an agent to assist you under state statute, so not multiple people for healthcare, but one agent, and then backups are great. So we have a healthcare proxy, and then you can also do something called a living will. And a living will is a document in which you put into writing what your wishes would be about being kept alive artificially. So things like artificial nutrition, hydration, feeding tubes, and respirators keeping you alive. And many people come to me and say, if I am in an irrecoverable type of situation, I do not want to be kept alive by artificial means. If you feel that way, that needs to be in writing so that your doctors know that, your family knows that, and they have an opportunity to rely on something if they're having to make those end of life decisions, because those are hard decisions to make at any time. In the best of circumstances, they're very hard decisions, but if you've put something into writing, that's going to help alleviate some of the burden off of your agent. And I'd highly recommend that you put that into writing one way or another. So some people say, do everything that you can to keep me alive. Other people say, I would not want to be kept alive if I was irrecoverable. Whatever your wishes are, just put it in writing so that your agent knows what to do. And the last of the three medical or healthcare directives that I mentioned is a MOLST, a medical order for life-sustaining treatment. A MOLST is a very specific document. It's bright pink in color. You would fill it out with your physician, and it goes through a series of questions. If you're in this circumstance, what kind of treatment would you like? If you're in this kind of circumstance, what kind of treatment would you like? And it asks a whole series of questions, and you answer those questions with your physician to specifically indicate whether or not you would want intervention. So as an example, if you have been very ill for a long time and you had simply a heart attack and you say, I wouldn't want to even be resuscitated at all, then you really should have a MOLST in place. And that document should be posted in your home on your refrigerator so that if EMTs arrive, they know that you do not want to be resuscitated and that there's not going to be any intervention. So again, consider doing a healthcare proxy, a living will, or a MOLST. Any of these documents will work depending on the specific wishes and cares that you have. Make sure that you have those in place so that your family or healthcare agents know what to do and specifically, what direction they need to take in order to assure that your wishes are being followed. Any questions on the healthcare proxy?
Not at this time.
Okay, great. I think I see a question here. If we die, do I have to write down what I want done with my body, or can my daughter make this decision? So I'm trying to see the chat on the side if I can. So you really need to put into writing. Your executor can decide about what to do for funeral instructions, but if there's something specific you want done, put it into writing so there is no question. Specifically, if you desire to be cremated and you want something done with your cremated remains specifically, put that into writing, because cremation cannot be undone. It's a process that once it's done, it can't be undone. And the opposite can be done. You can be embalmed and later cremated, but you can't be cremated and uncremated, obviously. So if you want something specific done, put it into writing. All right, moving on to the fourth of the basic documents. As I mentioned, we have a last will and testament, disposition of remains, a healthcare proxy, and the fourth basic document is power of attorney. So a power of attorney is a legal document in which you, in writing, appoint an individual or multiple people. You may have more than one power of attorney agent to assist you with all of your financial matters if you're alive. It's usually used when you're incapacitated in some way, but it doesn't have to be. You don't have to be incapacitated. It could be just a matter of convenience, but somebody to do things like dealing with your real estate, dealing with your banking, dealing with your investments, filing your taxes, all the stuff we would ordinarily do for ourselves. But if we had some reason why we can't do this, we have somebody in place that can step right in and take care of these things. So you may have an experience where if you've even tried to call about a credit card for another individual, like even your spouse or somebody that you live with, a credit card or a utility bill, the cell phone bill, whatever, they won't talk to you. You have to have a legal document that appoints you as the agent, and that legal document is a power of attorney. So you want to make sure that you have this in place and that you have selected who the person is or persons that are going to be doing these powers for you, and also designate what those powers might be. Within the power of attorney document, it's important to know a couple things. One is that it does terminate when you die. So the power of attorney is only good during lifetime. And the moment that you pass away, both the power of attorney and the healthcare proxy document go away. The New York state law allows us to appoint, again, multiple people, so you can have more than one power of attorney agent. If you have more than one agent, you may specify whether they have to do everything together. You know, one can't do anything without the other, or you can say either of my agents may do transactions. It's more convenient for your agents if they do things independently, just that way they don't have to go to do everything together, but whatever you feel comfortable with. We do have a few options in New York State with regard to power of attorney, and one of the options to consider is that you may appoint a monitor. A monitor is a third party that can serve sort of as big brother and periodically check in on your agent and seeing what they're doing. Now, if you feel it's necessary to appoint a monitor, I would say maybe think about who your agent is, because you should really feel comfortable about the agent to the point of not really needing a monitor, in my opinion, but you may appoint a monitor. Okay. You may also indicate whether or not your power of attorney agent is going to be compensated or receive payment for doing this. Most people don't pay their family for being power of attorney, but you could pay somebody to do it, and you can set what that compensation is within the document. Additionally, one of the more important things within the power of attorney statute is the ability to do gifting on your behalf. So the ability to move assets or change beneficiary designations, etc. And it seems counterintuitive for us to say, I would ever allow someone else to make a move of my assets. Why would I do that? Well, there are legitimate reasons why it comes up, and it comes up most frequently for either tax planning or protecting assets from long-term care costs or the nursing home. So that's the legitimate reason. If I'm going into a nursing home and I want to try to make sure that my family can do everything that they can to protect my assets, we need to make sure that the power of attorney document contains the ability to do gifting. I see that there's a question here. Does the power of attorney include medical decisions? It doesn't. So power of attorney is for financial matters only. For medical decisions, it has to be a healthcare proxy or a living will. Any other questions on the chat about healthcare proxy or power of attorney so far?
I don't see any yet.
Oh, I see. Should we have multiple primary power of attorneys? So you should have in any document, whether you do a will, a healthcare proxy, a power of attorney, a disposition of remains, I would always recommend that you have a primary agent and at least one backup. As an example, I appoint my husband as my agent, and if he is deceased or unable to serve for some reason, you know, I have one of my children listed, and maybe my other child as the secondary. So you always want to make sure that there's a backup to the extent possible. And you may have multiple primary power of attorneys. Yes. So I could have my two kids as my power of attorney agents, and I can specify whether they have to do everything together, or I can specify whether, you know, they can do something independent of each other. Either of them can do transactions. The power of attorney statute allows for that. No problem in New York State. So I do want to also let you all know that last June, just a little over a year ago, we got a new power of attorney statute in the state of New York. They have changed the power of attorney statute several times over the years. There was a major overhaul in 2009. A small tweak in 2010, and then again a change in 2021. And the good news is any prior power of attorney that you had done is still effective. So the change in the law doesn't invalidate any of the prior power of attorney documents that existed. They still do exist. So they made a couple changes to the documents, specifically with regard to, you know, record keeping for the agent. The agent has to keep records. They've now specified that about some of the duties that the agents have. They've also indicated that, you know, a financial institution doing business in the state of New York has to honor the power of attorney. And if they don't, there's some teeth on their refusal. Like they can be held accountable for refusing to honor the power of attorney as well. So a really important document, it's important to know if you don't have a power of attorney in the state of New York and you become incapacitated, then your family is going to be forced to go do a guardianship proceeding, which is a court proceeding to have you declared incompetent. It can take a long time. It can cost a lot of money. And frankly, somebody that you would not want involved could in fact be appointed as the agent. And we want to avoid that if we can. Any questions on power of attorney?
There is one. How do you terminate a power of attorney?
So you can terminate, you can revoke a power of attorney by a document, a one-page document that says on July 12th of 2022, I appointed Sally Jones as my power of attorney agent. I hereby revoke that appointment. You have to then give notice of the revocation to the agent and to any financial institution who may have received that power of attorney, so they know that Sally Jones no longer has authority to serve on your behalf. So it's really a simple document that you sign in front of a notary revoking the old power of attorney, but you do have to give notice to the former power of attorney agent and then any financial institution who may have been relying on that power of attorney. And now they know I can no longer, we no longer take instructions from this person. Any other questions on power of attorney or any of the other documents we talked about? Last will and testament, disposition of remains, healthcare proxy, power of attorney. No? Okay, so those are the basics. As I mentioned at the very beginning, I wanted to talk about basics and then start layering on some complexities. So every single person should have those 4 basic documents in place. No matter how old you are, no matter how many assets you do or do not have, those documents are going to avoid disputes. They're going to allow you to put into writing what your wishes are and appoint agents that you select to be in control of your assets and your care. So those are really important documents. Again, last will and testament, disposition of remains, a healthcare directive of some sort, and a power of attorney. Make sure you have them. Periodically review those documents. If your life circumstance might change, it may warrant changing your documents. What do I mean by that? Well, let's say I am a married person. My last will and testament left everything to my husband and then to my kids. My husband has now died, and maybe it warrants me changing my documents and appointing my children or doing something different. Or more importantly, I'm a married person and my spouse is now going into a nursing home situation, or we anticipate that, and my will leaves everything to my spouse. That doesn't make sense anymore. We would want to change that and maybe limit what we're doing. Okay, so we want to periodically review these documents, make sure that the plan still makes sense, make sure that the person that we have appointed still makes sense. Every 5 years or so, pull those documents out. And then also review those documents if there's been a major change in your life circumstances. I see that there's a question, do these documents need to be written by a legal professional only? So from a legal perspective in the state of New York, if you do a written document that meets the requirements that New York state law requires, they don't have to be written by an attorney. The problem is I have seen far too many times that people believe they have a legal document that is valid and it is not. And now it's too late. So I would highly recommend that you do work with a legal professional to do any of these documents we've talked about. They're important. We want to make sure they're done right. We want to make sure that they're appropriately witnessed, etc. So I highly recommend it. Again, legally, you can do it on your own as long as you meet all of the requirements that New York state law requires. The problem is if you're not an attorney or a legal professional, you may not know what those requirements are. But they're important enough documents to warrant you spending some time talking to an attorney. And it certainly doesn't have to be me, but anybody that you would choose to work with about these things. So I want to move on to sort of the next layer of complexity. When I am talking to clients about estate planning, there's sort of 2 ends of the spectrum that people have concerns about. The first is that people are often concerned about avoiding estate tax after death. And then people are worried about protecting assets from long-term care or from the nursing home. So the good news is that most people do not have an estate tax issue when they die. The estate tax thresholds are quite high. So right now in New York State, the current estate tax threshold is $6,110,000 per person. So you can pass in excess of $6 million on to your heirs without having to pay any estate taxes. The current federal exemption right now is over $12 million. It is currently scheduled to sunset in January of 2026, back to where it was before tax reform, but that's still, over $5 million. So again, unless we're talking about millions of dollars, most people do not have to worry about estate taxes on their estate when they pass away. Somebody asked the question earlier about, do you have to pay income tax when you have an inheritance? Again, covering that question, when you inherit money, it is not earned income. So there is generally no income tax on the receipt of inheritance unless it is a tax deferred item. So if I just receive a piece of real estate or a bank account, just a brokerage account, there's no income tax that I have to pay when I receive that. If it's an IRA or a tax deferred item and the decedent had not yet paid the income tax, as I take the money out, there's going to be an income tax consequence. Other than that, no income tax issue. If you do find yourself in this situation, a good problem to have, but if you find yourself in a situation where you do have an estate tax issue, there are things that people can do to try to minimize the size of their estate by the time that they die, so that there's avoiding some tax. So you can currently give an annual gift tax exclusion of $16,000 per person per calendar year. So I can give $16,000 to as many different people as I like every calendar year to minimize the size of my estate. And I don't have to file a gift tax return. It's a nice way to minimize my estate. However, keep in mind, it is a freebie of gifting for tax purposes, but it is not a freebie when we're talking about Medicaid. So this gift tax exclusion, you're allowed to do it for tax purposes, but for Medicaid, they consider all gifts that you make. That's a common misconception. People think that they have this lifetime gift every year that they can do, and it's allowable under Medicaid. It is not. So charitable giving, other ideas that are listed here. Again, if you have a situation where that's a good problem to have, but if you have that situation, talk to an attorney that does this kind of work so that you can minimize some estate tax issues. The more common situation is planning for the nursing home situation. Oh, we had a question. Does the other person get taxed on that gift? And the answer is the same as an inheritance. The general rule is no. If I give somebody $16,000 of just cash, I don't have to report it as a taxable gift, and they don't have to report it as earned income. Their only exception would be if there was some sort of tax deference on the asset that I'm giving away. So you only pay income tax on something that you earned or something that was tax deferred. There's no other questions, correct? Okay, great. So the next layer of complexity is that other end of the spectrum. So we said estate taxes, people with larger net worth, and then the more common one is I want to protect assets from a nursing home situation. I'm concerned about long-term care costs, etc. So that conversation sort of has to start with, well, what does a nursing home cost? How do we pay for that? Like, what are the sources for payment? So in Western New York, the average cost for an assisted living facility is going to be anywhere from about $3,000 to $6,000 per month. For skilled care, when we think of I need help with all activities of daily living and I'm custodial care, that's going to jump up to anywhere from like $12,000 to $17,000 per month, depending on the facility that you're in and the services that you're receiving. And we say, well, that's a lot of money. Like every month, that's a lot of money. How do we pay for that? So there are 4 sources of payment that we look to. And the first source of payment is strictly like private pay. You just cut a check to the facility and you pay your own way and spend through your money. Most people don't like that idea. I'm losing my assets that I have. But that is in fact the first source of payment. The second source of payment that we look to is to see, is there any long-term care insurance out there? So do you have any nursing home insurance? And, some people have it. And if you have it, it's a great tool to have in our bucket to be able to provide some money to pay for care. But frankly, most people don't have it. It's kind of expensive and hard to get. So most people don't really have it in their arsenal of payment sources. Then we look at Medicare. And lastly, Medicaid. Now, Medicare is basic hospitalization coverage that you get through Social Security. And Medicare is there to cover a hospital stay. And it's also there to cover a short-term stay in a rehabilitative situation following a hospital stay. So it's usually something like you fall and break your hip and you're at the hospital and you have surgery, and then you go out for physical therapy, occupational therapy. Medicare will cover the hospital stay, and they will cover up to 100 days in the rehab setting. Now, before COVID, it would normally be that you had to have been hospitalized, admitted to the hospital for 3 days or longer, and then transfer from the hospital to the rehab setting. During COVID, they've waived that 3-day waiting period. So right now you can go directly from hospital into rehab without that 3-day period of time to wait. And you can start the Medicare trigger. Now, I mentioned that Medicare will cover up to 100 days. Nobody actually ever rehabs that long. The first 20 days from day 1 through 20, Medicare covers everything with no copay. From day 21 through 100, Medicare will cover, but there is going to be a copay of like $160+ per day. And frankly, most people, by a couple weeks time, Medicare is essentially cutting them off. And now they're either looking at trying to apply for Medicaid or privately paying. Now, Medicaid is a welfare program. You have to be needy in order to qualify. So here are the resource allowances for Medicaid. If we have a married couple and one spouse continues to live at home and the other spouse is in the facility, the community spouse living at home, the community spouse can keep a fair amount of assets. The community spouse can keep a primary residence, a nice primary residence, one motor vehicle, a nice one, regardless of value. And the community spouse can have $74,820 of other resources like bank accounts, cash value of life insurance, etc. And then monthly income every month of $3,435 per month. This is for the community spouse living at home. The person going into the institution, the institutionalized individual, can only have $16,800 of total resources like bank accounts, etc. And they get to keep $50 per month of income for incidentals to maintain themselves, for haircuts, etc. But you have to be needy in order to qualify for Medicaid. Okay. Now, the worst case scenario would be I no longer have a living spouse, or maybe I never was married. I'm this sole individual. I end up having to go into the nursing home. In order to qualify for Medicaid, I have to get my assets and resources down to $16,800 of total resources. Okay. So do we have any questions on that? Nope. Okay. So one of the other important things to think about for Medicaid is, because Medicaid is a welfare program, they have these limitations, these resource limits, and they also have something called a look back period. So when we apply for Medicaid for institutional care, there is a 5-year look back period. So we apply for Medicaid and they require us to be down to these levels. And they also look back for 5 years from the date of our Medicaid application to say, did you give away or divest yourself of assets in this 5-year period of time? Because the theory is this: these are your assets that you've amassed during your lifetime. You're allowed to do whatever you want with your assets. You're allowed to spend them. You're allowed to give them away, whatever you want. But if you give them away, if you choose to give them away to divest yourself of assets, you cannot then turn around and ask the government or other taxpayers to pay for you in a facility. But if you did it more than 5 years ago, that's fine. But Medicaid has for institutional care this 5-year period of time that they're looking. Now, some gifts falling in that 5-year window are going to be fine and exempt. So gifts between spouses, no problem. So I can give things to my husband give things to me. That's no problem. No penalty for any of that. There are a couple exceptions that apply as well. So if I have a child who has been, they've moved into my home and they're helping me as a caretaker child, and they've been doing that for 2 years or longer, I'm allowed to give my house, my primary residence, to that child, and there's no penalty for that, even if I do it right before trying to qualify for Medicaid. That's one of the special exceptions. Also, if you have a certified disabled child in your family, you're allowed to make some gifts to that individual certified disabled by Social Security. There are some exceptions there as well. But the general rule is, if you give away assets, you have to have done it more than 5 years in advance before trying to qualify for Medicaid without the risk of a penalty. So let's assume that I did make a gift to Medicaid. Or during the Medicaid window. So I made a gift to somebody within the last 5 years. How does that work? So Medicaid is going to say, if you made a gift in that window of time, they take the value of that gift, they divide it by a regional penalty rate, and they come up with a number of months that you're going to be ineligible for Medicaid. And then we have to figure out how are we going to pay for Medicaid, for the care during that Medicaid look back period. So there's a plan. You want to work with an attorney that does this kind of work. And there are things that can still be done. So the other thing to keep in mind is in this window of time that Medicaid is looking at, they're really only going to penalize you for gifts. If you legitimately spend your money, that is okay. So as an example, if we have a married couple and one spouse is going to stay home, the other spouse is going to the institution, we know that the spouse at home is allowed to have a house and a car. And so maybe we take some of the excess resources that they have and we do upgrades to the house. So maybe there's a new roof and a new furnace and it needs a new driveway, or we need to upgrade the vehicle because we're driving an older car. We can get a brand new car. All of those things are legitimate. You can also prepay for funerals. That is all legitimate. Medicaid lets you do all of that, no problem. Even if it happened right before qualifying for Medicaid, not a problem. Where we have to deal with issues would be if we gave away assets and now are trying to qualify for Medicaid, we have to come up with a plan. So here's a question. How can you explain that to an older parent who thinks they can take cash out of the bank? They say they purchase large percentage. So they can't. So, okay. So when you apply for Medicaid, Medicaid will require you to produce 5 years, 60 months worth of all of your bank statements. They look at everything, and they're looking in Erie County, they're looking at all transactions of $2,000 or more. So whether it's a deposit, a withdrawal, a transfer, whatever, they're looking to see what did you do with your assets. If there is a sudden depletion of assets and there's no corresponding receipt, the law presumes that you made a gift and then they impose the penalty. So even if you legitimately spent it on something, if you can't prove that, Medicaid assumes the presumption in the law is that you made a gift. So the only thing that you can do is sort of reiterate to your parent that the rule is you have to be able to prove what you did. If you cannot prove what you did, the presumption, it works against you, and Medicaid will impose a penalty there. There's a question, are there rules about excessive purchases that are too expensive, too many cars? They only let you have one motor vehicle that's exempt. So you can have the nicest car. You could be driving a Cadillac or a Range Rover or whatever. That's okay, but it has to be legitimately for you or for your spouse, your community spouse. That's okay. You have to be able to prove it with receipts, but only one vehicle is exempt. Here's a question. If the institutionalized individual owns their home, which was their primary residence, how does that work with the 5-year look back period? Okay, if I'm going into the institution and I no longer have a living spouse, I can't keep my house and qualify for Medicaid. They will require me to essentially liquidate my house, spend down the assets, unless one of the exceptions apply, like I have a caretaker child exception, etc. Now, there is also a little rule under the Medicaid laws, which says if I intend to try to go home, I'm in the nursing home, institutionalized, but I'm really trying to get home, you can sign a statement of intent to return, which is basically an affidavit telling Medicaid, I'm going to try to go home. And that in that situation, they will exempt the house from consideration from Medicaid for a short window of time, like 6 months. The problem, practically speaking, is they don't allow you to use any of your money to maintain that house. So now you've exempted that house from consideration for a few months, but I can't, but I can't use any of my money to pay the taxes or the utilities. And how is that house being maintained? So it's a bit of a catch-22. And if you do a statement of intent to return home, they do place a lien against the house. So when you sign that statement of intent to return home, you're basically saying, they're not going to count the house against me at this point, but if Medicaid opens a case, there would be a lien against my house. Question regarding the caretaker child receiving the parent's home. How does this happen? Are there documents needed to show that the care was provided? Do they need to be specified in a will? It's not specified in a will. It's actually a deed transfer. So the parents actually sign a deed and all the corresponding documents. There are 4 documents in Erie County that have to be signed. You do want to work with an attorney to do that, where the transfer is from the parents to the child. And they need to sign an affidavit of what they did. And it can just be, I did the laundry every week. I, did the grocery shopping. I mowed the lawn. I helped them with physical care, whatever it is. Medicaid would require the child to sign an affidavit about the care that they provided, and the deed transfer needs to be done and incomplete before the application for Medicaid is filed. But it's not in a will, because a will is only relevant after you die. So it is something that is done by the parent while they are living before they make the application for Medicaid. Okay. The other thing I want to talk about is the differentiation between income and resources by Medicaid. So Medicaid is going to classify assets as either being a resource available to you or an income stream available to you. So resources are going to be things like real estate, cash value of life insurance, bank accounts, brokerage accounts, etc. Income is going to be Social Security, pension. If you have a retirement account like an IRA, as long as you are taking the required minimum distributions off of that retirement account, it is considered income and not resource, which is a huge thing. So you could have $1 million in an IRA, and Medicaid does not count the $1 million. They only count the required minimum distributions that are coming off as income to you. We have a question: will the life insurance be lost? The cash value of life insurance is considered a resource. So if it has too much resource, you're not going to be able to keep it if it pushes you over the resource level. If it has a resource value, a cash value that's under the resource level that you're at, you can keep it. But whatever that cash value is counted as a resource that you have to calculate into the process. Okay, so as you can see, this stuff can get complicated. I do highly recommend that if you're in a situation where you have any questions, that you do talk to an elder law attorney. Again, it doesn't have to be me. I am here to provide free information to the public as a service, but I'd highly recommend that if you're going to be involved in any of these types of plans, that you do talk to an attorney that does specifically elder law, because it is complex. There are a lot of pitfalls, and we want to make sure that you're covered in the best way possible. The other thing I want to leave you with is sort of the understanding that there is this 5-year look back period that we talked about. And sometimes we have a crisis, an emergency happens, and we're not going to make it through the 5 years. What can we do? There are still things that can be potentially done to save some resources and assets. You do need to work with a qualified elder law attorney to come up with some of these plans. But things like potentially spending on upgrades for the community spouses benefit, that's available. Additionally, there is a much more complex plan that is called a gift and a note crisis plan. And just a very simple snapshot. If, as an example, we have $300,000 of excess resources. Okay, so $300,000 is excess, and we're going to give half of that away. $150,000 is going to be given away, knowing that there's going to be a penalty associated with that. We know that we made a gift within the 5 years, there's going to be a penalty. How do we get through that penalty? Well, the other half, the other $150,000, is structured in a promissory note that repays the parent to get them through the penalty that's associated with the gift. So it's complicated, but consider that we could potentially save maybe about half. Even if you aren't going to make it through the 5 years, there is a way to try to protect assets. But again, you have to work with an attorney that does this kind of stuff and know that these rules are changing all the time, and we need to be very thorough with the plan and going through everything. The question is, can I keep the payout of the life insurance? So I'm not sure if you're talking about the death benefit. So if there's cash value to the life insurance, I have a policy of life insurance that maybe has a death benefit of $25,000 when I die, but while I'm alive, the cash value is $5,000. Medicaid will count the $5,000 as a resource against me during my life if I choose to keep that asset. My family still gets the $25,000, yes. So I'm not sure what that question was related to. I hope that answered the question. Couple things I want to just briefly kind of cover, and then we can open up to any questions or chats that you have. There are a few things that are commonly done that people like to talk about and ask questions about. So one of the things that we often will do is in advance, well in advance of the 5 years, if we think we're going to have time, we think we're going to make it through the 5 years, what can we do? We can start the process of giving away assets now and hope that we clear the 5 years. Because if I give away assets and I clear 61 months, I'm good. So that's our goal. Our goal is to get the information out so people start giving away assets sooner. How you give away assets is important. So we would normally recommend using something called a trust, an irrevocable income only trust, where I actually give away assets into a trust entity as opposed to just giving those assets to my children directly. You could give assets to your children directly. However, once you give those assets to those children, if that child gets sued, they get in a car accident, they go through a bankruptcy or a divorce, your assets are now available to the creditors of your children because you just gave your assets to your kids. So the more protected and sheltered way of doing it is to use a trust entity, which is what we would normally recommend. But you want to think about these things, start the process, start talking about these things. What can we do? And then one of the other common things that people do is give away their home to their children while mom and dad retain rent-free life use to live there. That's also common. Again, you can do it that way. You can use a trust. There are multiple ways to do things, but it's very common. Your question here, is a funeral plot an asset? Okay, so a funeral plot is considered an asset. How, from Medicaid's perspective, they let you have it. So Medicaid lets you have a burial plot. They let you have a prepaid burial fund. As long as it's irrevocable, prepaid, and you can't get the money back out for yourself individually, that's totally fine. They don't count it against you. If you have a burial plot that you want to, transfer to somebody else before you die, you can do that. You have to do that directly with the cemetery. But from a Medicaid perspective, they let you have a burial plot and they let you have a prepaid funeral fund. No problem. They don't count that against you. Other questions that you all might have before we sort of wrap up? Anybody else?
Another question that just came in. Are there advantages to putting the home deed in your children's name? So there are advantages to doing that. So if you transfer ownership of the house to the children, it avoids probate after you die because the children are already the owners. That's great. As long as you retain rent-free life use for the parent can live there rent-free. Nobody can charge them rent. Nobody can kick them out. It avoids probate after they die. And once you clear 5 years, that house is now protected from Medicaid. So it's a really nice planning technique that people often use. However, the risk is if the child or the children gets into financial difficulty, they're on your deed. So you may have to worry about their creditor putting a lien against, their interest of your house. Depending on the financial circumstance of the kids or their stability, it may totally make sense to do that. It's a very common technique. Would the house be taxed when it is inherited? So if I own a piece of real estate, or even if I own an interest in the piece of real estate, and rent-free life use is a legal interest, it's called a life estate. So as long as I have any interest in that piece of real estate, after I die, the children get what's called a stepped up cost basis. And so there's no tax, there's no capital gains tax to them or anything like that. Their cost basis in the property becomes whatever it was worth on the date that I died. If they turn around and sell that property, they don't have to worry about capital gains. So as long as you own an interest in the property through the date of your death, any type of interest at all, even life use, that's enough to give them the stepped up cost basis. For Medicaid, is a funeral plot an asset? So for Medicaid, it is an asset, but not an asset that they count against you. They exempt a funeral plot and a prepaid burial. Those are exempt assets. So they do count them as assets. They say, yes, you have it as an asset, but they say it's exempt and it doesn't count against the resource allowance that they give you. So if you're allowed to have $16,800 of resources, the fact that you have a funeral plot and a prepaid funeral doesn't count against that $16,800. Any other questions? I don't see a question, Linda, but we have a comment that you've made things very clear. So thank you very much. Thank you. Absolutely. Absolutely. Okay. So here is, if the house is owned in a life estate, will it still trigger ineligibility for the 5-year look back period? Yes. So if I transfer ownership to my children, I retain rent-free life use. I have to clear the 5 years before that transfer of my house is protected from Medicaid. So you still have to clear 5 years, even for that. Do you own the house if it is put into the trust for the kids? So no, if I give away the house to my children and I retain rent-free life use, I am no longer the owner. If I put my house into a trust,
and I still have rent-free life use, I'm no longer the owner. So in order to protect the asset from the nursing home, you have to relinquish ownership and control. That is always going to be the trade-off. So when you're planning for Medicaid, that is the biggest thing to keep in mind. If I am going to protect it from a nursing home and Medicaid, I cannot be the owner or have control. There's the way and the balance and the tension between those two things. Any other questions? I think we've come to the end of the materials. I did offer, if anybody would like this presentation emailed to them, no problem. You can email me at grear@pbelderlaw.com, and I'd be happy to just shoot you an email of the PowerPoint so that you can have it, at your fingertips. Again, these rules, I mentioned this earlier, but these rules change every year. So we get new Medicaid resource allowances, we get new taxation allowances, everything changes every year. So this presentation would change slightly come 6 months from now. But the overall rules themselves are pretty standard and have remained true for decades. But the allowances and the amounts change from year to year. The next question came, you won't get an automatic email because I don't have email addresses for everybody. So you'd have to email me.
Linda, actually, I was gonna tell you all for joining. This presentation has been recorded, and we will also make the PowerPoints available on erie.gov/ELD, the same way you registered. We'll put that information on there so you have access to it. So Linda, you don't have to email everybody the PowerPoint. We'll provide it for everyone who's joined today. You can find it where you registered on erie.gov/ELD.
Okay, perfect. And if you want to email me directly, it's grear@pbelderlaw.com. Just shoot me an email and then I will email the PowerPoint to you directly. If you'd rather have direct contact, no problem.
Well, thank you, Linda, for providing such comprehensive information. I think everyone enjoyed from the comments and the questions, have learned a lot today. I appreciate you coming back. This is Linda's 3rd year joining us virtually. I appreciate it.
Sure.
Everyone else, please join us again tomorrow for our presentation on adult care facilities, what residents and families need to know. We'll hope to see you tomorrow at 10 o'clock. Thank you again, Linda.
Thank you, Christy, and thank you, everybody. Have a great day.